This week on Lewis on the Law, I've got another great show for you. I have attorney Cole Thaler on with me, and we're going to talk about House Bill 346 and retaliatory evictions.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I have got a great show going for you today. I have attorney Cole Thaler on with me, and Cole is the Safe and Stable Homes Project Director for the Atlanta Volunteer Lawyers Foundation. And it's Atlanta Volunteer Lawyers Foundation. That's correct, right?
You got it, James. Thank you.
Yeah, you're welcome, and I'm glad to have you on here. I've had people from Atlanta Legal on. I've had Lawyers for Equal Justice on. I've had Georgia Heirs Property Project on. So I'm really excited to get you guys on here.
Thank you. Excited to be here.
Yeah, can you tell me a little bit about Atlanta Volunteer Lawyers?
Sure. So we're another legal nonprofit similar to the ones that you've hosted on your show before. We have been around, actually this year is our 40th anniversary. So we're celebrating 40 years as a nonprofit. And we came into being to bridge the gap between low-income residents of the metro Atlanta area and attorneys in private practice. So in the metro Atlanta area, there's about 25,000 attorneys in private practice. And as wonderful as legal aid is, it's still a small organization compared to the need. So it was a bunch of smart attorneys came together 40 years ago and realized that if we could tap into the power of those 20,000 private practice attorneys, even if each of those attorneys just took one or two cases a year, they could make a huge difference in the amount of justice out there for low-income residents who can't afford to hire an attorney. So we really exist to be the matchmaker or the liaison between, in my program, tenants who are low income and are having problems with their landlords and private attorneys who are looking for pro bono opportunities, looking for work to do to give back to the community, but need some help finding that client.
Yeah, I myself take at least one pro bono client at a time. I don't do more than one at a time because it can get a little bit work intensive. So what kind of things, is it just any kind of legal issue that you help people with?
No, so we have a couple of main programs. So if you think of Atlanta Volunteer Lawyers Foundation as sort of one umbrella, we're sort of split into two halves, which we call the Safe and Stable Homes Project, of which I'm the director, and the Safe and Stable Families Project. A woman named Jamie Perez is the director of that program. Safe and Stable Families really help survivors of domestic violence, intimate partner abuse, who are seeking protective orders and then seeking divorces, child support, that kind of family law issue. They have an office down at the Fulton County Courthouse here in Atlanta, and that's the work that they do. Whereas my side, Safe and Stable Homes Project, we almost exclusively help, low-income tenants who are having some kind of problem with the place that they rent, whether it be repairs and conditions, a security deposit not being returned, eviction, illegal eviction, which we can talk more about what that means. Mm-hmm. So that's the work that I do at AVLF.
And is it mostly, it's mostly landlord-tenant issues then, right?
Yes, we have a very small sliver of the work that does unpaid wage cases for workers who didn't get paid. And the reason we have held on to that is because so many workers need that paycheck to pay their rent. And if you don't get paid for the work that you do, eviction is sure to follow.
Yeah, it sure is. And that's not a great defense when you get into housing court.
Not a defense at all.
Okay, so let's talk about the intake requirements. Is there a monetary level or something?
There is.
Okay.
Yeah, for the Safe and Stable Homes Project, we do have a couple of intake requirements or eligibility requirements, I should say. The person needs to live in either Fulton or Clayton counties. So because we are still relatively small, we are limited to those two counties in Georgia. And they have to be in a household that earns under 200% of the federal poverty level. So just to give you a concrete number for that, for a household of 4 people, that's about an income of $50,000 a year for a household of 4. So that's still a very low income family. For a household of 1, it's about $25,000 a year. People need to make that amount or less to be eligible for AVLF's help.
Okay, I can remember back in the days when I made $25,000 or less, but I just scraped along living on people's floors.
Right.
Okay, so how did you get involved with AVLF? What made you want to get involved with them?
So before I was at AVLF, I was working at another organization called Georgia Legal Services Program, which is kind of like Atlanta Legal Aid.
Does that still exist?
It does. Okay. So Atlanta Legal Aid works in the 5 metro Atlanta counties. But as I'm sure you know, Georgia actually has 159 counties. So Georgia Legal Services Program serves the other 154 counties. So
That's pretty important because I've heard that like 70 to 80% of the attorneys in Georgia are all here in Atlanta, and we're all battling for dollars.
that's very true. And unfortunately, in the deep south parts of Georgia, the very rural counties, there are sometimes, if you can believe it, no attorney in the entire county.
Yeah, I think when I had Atlanta Legal Aid on, they said there's something like 5 counties in Georgia where there's not a single attorney other than maybe the county judge.
That's right, who probably travels around to different counties. It's hard to believe. So I was working at Georgia Legal Services, so I was driving to rural Georgia, helping people with food stamp issues and unemployment claims and Medicaid issues and things along those lines. So I loved that work. It was very exhausting after a while, and I decided to move to AVLF so I could focus on one geographic area and one substantive area. So that's when I really honed in. I was doing some landlord-tenant work before, but now it's exclusively what I do just in Fulton and Clayton County.
Okay, that's incredible. That's a really varied level of experience. You're getting into a lot of things.
Yes, I've done a lot, and the consistent theme has been serving clients rather, who really don't have the resources to go out and pay a $5,000 retainer, who just are trying to survive, trying to scrape along, like you said, and run into a problem with the law. They have the same rights as a rich person, but they may not have the means to enforce those rights without a pro bono attorney or a free attorney.
Yeah, I think that's really important, and I oftentimes take people on a sliding scale too. I mean, I'll offer and. There's a line, since I'm in private practice, I have to actually make a living too.
Right.
But if I get an attorney that's like, I get a lot of referrals from the Georgia Heirs Property Law Center because a lot of my work, especially I have heirs property in my background, in my family background. So I wrote about it when I was in law school. And so when I get clients referred to me from them, I'll actually take them on a flat rate fee and a sliding scale fee.
That's so important. I wish every lawyer in the state did that.
Well, I think there's got to be some areas in which you can give back. And so I'll take landlord-tenant issues one at a time pro bono as I'm going through the year. And I'll take heirs property clients on a flat fee because heirs property clients, especially a lot of those, it affects underserved populations. I don't want to say poor people, but people without the resources because it can be a huge job to clear an extensive heirs property project.
Absolutely. I've learned a lot about that from the Heirs Property Law Center, and I didn't realize what a huge problem that is.
Yeah, it's remarkably huge. Okay, so is there anything else we need to go over on Atlanta Volunteer Lawyers Foundation?
I guess the only thing I will mention is that our newest initiative in the Safe and Stable Homes Project that we launched back in 2016 is what we call the Standing with Our Neighbors program. And what we've done there is we're still working on tenant issues, still representing tenants who are having problems with their landlords, but we have gone out into the city and actually set up shop in schools, public schools. We're in 8 Atlanta public schools in high poverty neighborhoods where there are high eviction rates and high school turnover. So a lot of schools in the city have great teachers, great administrators, great curriculum, but 40 or 50% student turnover from year to year because the eviction rates are so high. The housing stock is so dilapidated. So AVLF has put 3 attorneys and 5 community advocates in schools to help really bolster those neighborhoods and stop that turnover.
Okay, that's really interesting. What do they do in schools? I mean, do they talk about evictions or the process?
Well, so they're office spaces in the school. So they become really part of the school family, the community. They become close with the teachers and administrators and all the neighborhood partners, the churches, libraries, you name it. And their goal is to find out who the bad landlords are in those neighborhoods, who are the slumlords.
There's a lot of them.
There are. And to connect with the tenants and say, hey, we're here. We're literally, you drop your child off at school every morning, just come in, sit down and talk to me. I'm a lawyer. Tell me about your problem. You don't need to go to Peachtree Center across town and pay $20 for parking. I'm actually right here in your community. I'm here to help you.
That is a great thing, and I can see how landlord-tenant issues and family law issues would be really helpful in some of those underserved population areas.
Absolutely.
Okay, we are almost at the end of our segment. Can you give our listeners some contact information for Atlanta Volunteer Lawyers?
Yes, absolutely. So Atlanta Volunteer Lawyers Foundation, you can find us online. Our website is www.avlf.org. If you have a legal problem or just want to hear more about the work that we do, you can give us a call at 404-521-0790. That's 404-521-0790. We'd love to hear from you.
You're listening to Lewis on the Law. My name is James Lewis, and I'm your host this week and every week. And if you have a serious legal issue, don't rely on what you hear on this radio program. This show is only designed to bring you information, and it is our goal to empower you, to help you understand what issues are out there, what issues may be affecting you, what resources are available to you. But this in no way should replace the advice of an attorney if you have a serious legal issue. You can always go ahead and give me a call at JamesLewisLegal.com, 404-610-0075. You can email me at james@jameslewislegal.com. And if I can't help you with your issue, I can direct you towards an attorney or a resource that may be able to help you with your issue. When we get back, we're going to talk about the eviction process before we get into House Bill 346. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week, and we are here to empower you, the listener. I'm excited to have attorney Cole Thaler on with Thaler. I wanted to say Taylor, and I always get stuck somewhere in the minute. Cole Thaler on with me, and he is the Safe and Stable Homes Project Director for the Atlanta Volunteer Lawyers Foundation.
Yes, sir.
Yeah, and we are going to now start to talk a little bit about the eviction process. So what happens during an eviction?
And first, let me thank you for inviting me on to talk about this. I think this is so important.
I want to thank you for coming on and being a guest on this show because it is my goal to try and provide our listeners with some information that can help people.
I think, there are so many renters in Atlanta and Georgia as a whole, and even if people don't think that eviction is something that could happen to them or will happen to them, a lot of folks are one missed paycheck away or one illness away from facing that eviction. And a lot of people don't understand the nuts and bolts of it. And it's really key to understand the basics about eviction, because if you don't understand, you could lose your home very quickly. So just to give you the basics, and a lot of what I'm going to say is true across Georgia, I will use some examples from Fulton County, which is the county I know the best in terms of eviction procedure. But here are the basics. It's actually quite simple. In Georgia, a landlord has to do one thing only before filing an eviction against a tenant. They must make a demand for possession. And that is the only requirement on a landlord before they go down to the courthouse to file that eviction. What is a demand for possession? The landlord must communicate to their tenant that the tenant has done something wrong, has violated the lease, has stayed too long, has not paid rent, and has to get out of that rented property, whether it be an apartment, a house, what have you, by a certain date. Mm-hmm. And the law does not specify how much notice the landlord has to give. Now, the lease may specify this. Mm-hmm. So I'll come back to this, I'm sure, lots of times. All tenants, anyone who's listening to this who's a tenant, read your lease. Make sure you read it backwards and forwards and know it by heart, because there is stuff in there that the law leaves up to your landlord to fill in that lease. So the landlord has to make a demand for possession. It doesn't even have to be in writing. Georgia law says it can be oral. It can be verbal. The landlord can come up to you and say, hey, I want you out of here in 72 hours. You haven't paid rent. You have to be out of here by Monday. And that is perfectly legal. But there does have to be some demand made.
Yeah, and I think just for the landlords out there listening, to be safe, you should probably get it in writing, because I've actually defended tenants before, and the landlord said I gave them notice, and the tenant was like, I never received notice, and the judge has asked the landlord, well, do you have proof?
Absolutely.
And then the landlord's pretty much dead in the water at that point.
Absolutely. And I say that too. I say smart tenants and smart landlords should do everything in writing. Mm-hmm. Otherwise, there's no proof. So that is what all the landlord has to do, make that demand for possession. Then the landlord can go down to the courthouse. Typically, evictions are filed in magistrate court, and file what in Georgia is called a dispossessory. So that's a word that sometimes folks are unfamiliar with.
That's a really fancy word.
It is. It is a confusing word. Sometimes people have a hard time pronouncing it. Mm-hmm. People call it dispo for short, dispo court. But what it is an eviction, or it's the piece of paper that gets the eviction process started. I will say that landlords must file evictions in court. Sometimes landlords, and we may get into this later, try to do things like changing the locks on their rented property.
Who would ever do that?
Unfortunately, lots of people that we hear about at AVLF, or cutting off the utilities or throwing someone's furniture out on the front lawn. Those are all examples of illegal evictions. That's not kosher. That's not permissible under the law. Must go down to the courthouse. And in Georgia, the eviction process is fast, easy, and cheap. And I say that as a tenants lawyer, so I'm sure there's landlords out there saying, well, not so fast. But from where I sit, it's fast, easy, and cheap. The filing fee is somewhere under $100 to get that dispossessory complaint filed. And here's how the procedure works. They file it. The county...
Wait, now, can I interrupt you here just
Please.
for a second? Because I actually had an email from a listener who asked me about the changing locks. I don't know if you want to talk about that here. I mean,
Sure.
I think it's a good place because you actually brought it up. So I actually had a listener who actually called me and emailed me and said, my landlord has changed the locks on me. And I think the landlord accused him of having an Airbnb. And maybe he did, maybe he didn't. Right. We don't know. But anyways, it wasn't in his lease that he couldn't have an Airbnb.
Okay.
So what options does a person have when that happens to them?
Yeah, it's a really terrible situation, and unfortunately, it does happen a lot. And you're right; it doesn't matter. Maybe the tenant did violate his lease. Maybe he did have an Airbnb that.
And I'm not saying he did, or I'm not saying he didn't.
Right. It doesn't matter. Even if someone doesn't pay rent, for months, which is a clear violation, the landlord only has one choice if they want to follow the law, and that's to go to the courts. But instead, if they break the law and do what's sometimes called self-help eviction or illegal eviction, like changing the locks, a tenant doesn't have a lot of great options. If they happen to come upon the landlord in the moment, which has happened, the landlord is there changing the locks or throwing their furniture out, I recommend that people call the police. Some officers will say, well, this is a civil matter and we're not going to get involved. But other officers will say, actually, landlord, you do need to go to the court and you have to let this tenant back in. So in general, I think that's a good first step if it's in the moment. Sometimes we get calls and someone says, look, this happened 2 weeks ago. I've been sleeping in my car. My landlord did this illegal thing to me. What do I do? And that's when it's really important to talk to a lawyer because
hire an attorney because you have to sue your landlord.
Yeah, and talk to legal aid, talk to AVLF where I work, and these are the kinds of cases that we will take for free. So even if somebody says, I don't have any money, I'm making minimum wage or what have you, don't let that stop you. Contact our organizations. We will make sure you get the help you need.
And if you're sleeping in your car, you probably need that help.
Yes.
Okay, so I interrupted you on the eviction process. Let's get back in. It felt like that was the right time to talk about that the listener call in.
Yeah, that's an important issue. So back to the eviction process. So the county marshal will bring that piece of paper, that dispossessory complaint or eviction complaint, to the tenant. And when they serve it on the tenant, I'm talking about service. The tenant in Georgia only has 7 days to file an answer. So this is very important. We hear from tenants who say, well, this court paper showed up on my door and I didn't know what it meant, so I just put it with all my other unread mail.
That's a mistake.
And that was 3 weeks ago. Did I do something wrong? And we have to tell them, unfortunately, you've missed your chance. So do not delay. Every moment is precious when you get that court paper. The tenant has 7 days to file that answer. Which they have to do at the courthouse. Some counties allow you to do it online, but I always recommend going down to the courthouse and filing it in person. And then you are entitled to a hearing. So you will get a court date and time and courtroom. Sometimes that'll be provided to you by mail. Sometimes they tell you just in person when you're there. You have the right as a tenant to be heard by a judge to tell your side of the story. Maybe you did pay that rent, or maybe you followed your lease and your landlord is not, being forthright with the court. Or maybe you have some kind of counterclaim or response. You didn't pay rent, but the reason you didn't pay rent is there was a terrible sewage flood in your apartment and you had to spend your rent money on a motel.
Now, when you answer, do you have to answer in any particular way?
Virtually every county in Georgia has a form answer. It's typically a one-page, like a checklist. So if you go down to the courthouse, bring the piece of paper you were served with, say, I got this on my door, I need to file an answer or a response, they will give you the form. It's usually designed to be pretty user-friendly. You don't need an attorney to explain it to you. It certainly can help if you do have a chance to talk to an attorney. But don't be intimidated about just going down to the courthouse, filling that out to the best of your ability. And it is important that you write on that answer, check off the things for, like, if your landlord did not make a repair, that is a counterclaim. You have to raise that. It's what lawyers call a compulsory counterclaim. So you must bring that up in the answer that you file so the judge and the court will understand the full picture of what's going on.
Okay. So are there some defenses? Are there defenses that can be employed here in this answer?
Yes.
I mean, are there set ones?
Yeah. So again, every county has its own different form. You know, it would be nice, I guess, if Georgia had a standardized answer form across all 159 counties. But
I mean, what I'm asking you is, can I go in there and say, you know what, I only worked 2 shifts this week. I was feeling tired, and I just couldn't pay rent.
So no, that may be an explanation, but unfortunately that is not a legal defense. Simply being unable to pay rent, you lost your job, you got sick, there was an unexpected bill. You know, that's life. That is an unfortunate housing circumstance, but that is not a legal defense. And unfortunately, even the great lawyers at AVLF will not be able to help you out of that situation. It is perfectly legal for your landlord to evict you in those circumstances. But, you know, defenses would include things like, you know, actually I did pay rent, or I offered my rent and my landlord refused to accept it. That happens. Or, hey, this person is not my landlord. I don't know who this name is on this form. This is, you know, some stranger. Or, you know, what my landlord is telling the court is false and I can prove it. Those are the kinds of things that are defenses.
Excellent. Okay, we're at the end of this segment. Why don't you give them some more contact information for Atlanta Volunteer Lawyers, Cole?
Sure. If you are a tenant who has a legal problem, please reach out to Atlanta Volunteer Lawyers at 404-521-0790. That's 404-521-0790. Or you can find us online at www.avlf.org. We also have a Facebook page, which you can find by searching AVLF on Facebook.
You're listening to Lewis on the Law, and I'm really excited by this, but we are now streaming on every single national medium. That's right. You can go to iTunes, you can go to Google Play, and there's a whole Spotify. There's a whole bunch of them I don't even know anymore. I'm not hip. I'm not up to date. So, but you can go online and you can stream Lewis on the Law from anywhere in America, at least. Maybe the world. I don't know. I don't want to make that claim without knowing. But I know we're national. So, and we are also AI compatible that you can go, hey, Alexa, play Lewis on the Law episode 44 with attorney Cole Thaler. And voila, it will start playing. I've tried this. I know it works. I have attorney Cole Thaler on with me. He is the Safe and Stable Homes Project Director for the Atlanta Volunteer Lawyers Foundation. They do great work in our community. And sitting here talking to you, you guys do even better work than I thought you did.
Thank you.
I mean, I'm impressed, especially the attorney in schools. That is such a great idea and so helpful because you're like on the front lines of where it's really going down.
Exactly. Thank you.
No, that is great and really badly needed. Okay, so we were talking about evictions and the eviction process. Now, I want to kind of get into House Bill 346, but let's talk about retaliatory evictions first. What is a retaliatory eviction?
Sure. So just to provide a little bit of context, this is where I've seen it come up. So remember that the tenants that AVLF represents are low income. So these are really vulnerable tenants. This may be the only housing that they can afford. The rent is low. There's enough space if they're a parent. It's close to their job, close to the kids' school, maybe close to church or close to family. But they don't have a lot of other options. So they really need this housing. They don't have big bank accounts or savings accounts where they can, hey, go rent a nice deluxe luxury apartment in Buckhead or something like that. They really need the housing that they've got. So what we see happen is that, let's say that landlord is really not making the repairs that they're supposed to be making. And in Georgia, across the state, it is the law that landlords must make repairs. Okay, so let's say tenant has been asking for a leak to be fixed and asking, and finally the landlord just says, I'm sick of this. You're asking for too much. I don't want to make that repair. I'm evicting you. Or I'm hiking your rent, or I'm taking some other action against you to punish you for you speaking up to get these repairs made. But the way this comes up most often is those evictions. The landlord says, you're too much of a squeaky wheel. You're asking for me to do too much. I want you out so I can find a tenant who won't require me to follow the law. And that is a retaliatory eviction.
Okay, so so it's just it can be qualified as a person who complains, and I mean, I kind of thought it might have meant lawsuits. I didn't actually do my homework and read through this, but I thought it might mean that people, because you have the whistleblower laws, but someone who actually brings it to the HUD attention or actually sues in court, then I thought it addressed those issues.
Well, it does address not so much about a tenant who's suing their landlord. At least House Bill 346 doesn't get into that. It does include, it applies to tenants who are asking for repairs, also tenants who make complaints to government agencies. So
okay, it does include that. So it is kind of a little like the whistleblower law.
A complaint to HUD, like you said, also to code enforcement. Most cities or counties, if not all of them in Georgia, do have a code enforcement office or department whose job it is to make sure all the buildings are up to housing code. And it's a tenant's right, and often tenants should call code enforcement or make a complaint online if they think their home is out of code, out of compliance. And what we see is, code enforcement comes in, tells landlord, hey, you got to make these repairs or we're going to fine you. And landlord says, hey, tenant, I wish you wouldn't have done that. I'm evicting you. Good riddance.
Oh, my goodness. Is that common? Is this a common occurrence? I mean, do you run across this?
We run across it on a regular basis. My perspective is skewed since the only people who call my organization, and we get calls from hundreds, if not thousands of tenants per year, are the ones who are having problems with their landlord. So I feel safe in saying most landlords don't do this. Unfortunately, however, there are a number of landlords, in my experience in the Metro Atlanta area, which is where I practice, who do punish their tenants in this way.
Yeah, I mean, if landlords will just change a lock on a tenant, then I'm sure that they will kick someone out who complains too much.
Exactly.
Okay, so House Bill 346, what exactly is it?
So this is really fantastic news for tenants in Georgia. And there were 41 other states in this country who passed similar laws before Georgia got around to doing it. So we are not, I will say, on the cutting edge of the law here. In fact, we're sort of on the trailing edge of getting on board with this very basic, frankly, tenant protection. So this is a bill that was introduced in this legislative session. It passed both houses. The Governor Kemp signed it into law just a couple of weeks ago. So this is a very timely conversation. It hasn't even taken effect yet. It takes effect on July 1st, 2019. So if you're listening, just know that this protection doesn't actually apply to you until after that date. But what it is, it's very simple, a very short law, and I encourage folks to go online and look it up and read it. But what it does is if a tenant has to prove a couple of things to trigger the protections of the law. First, the tenant has to prove that they took a protected action. What do I mean by that? It means that they asked for a repair or they called code enforcement. It also protects tenants who get together in a tenant association. They get together with their neighbors and say, hey, these conditions are so bad. Let's do something about it. Let's band together as a group. Sometimes landlords punish those tenants by just evicting everyone in sight. So those tenants are protected. So the tenant has to show first that they took that protected action. They did something that asked for help. And then they have to show that within 3 months of them doing that action, their landlord took sort of a punishing act against them, either by filing that eviction or dispossessory, which is where it comes up most often, hiking up their rent, decreasing services. So maybe, the landlord provides water to everyone, but now they're not providing water to this one tenant who complained a lot.
Wait a minute. So it actually applies to hiking up the rent too?
Yes, sir.
Well, that's really good to know.
That's right there in the words of the law. Or basically just did anything to single out that tenant, especially if it's in an apartment complex and the landlord is treating everyone else one way, but really singles out this one loudmouth, or I call squeaky wheel tenant for unfair treatment, that tenant has new rights under this law. Now, the law goes on, and it does protect landlords. It's a very well-balanced law because it says, look, landlords are still allowed to evict tenants even if it falls within this 3-month period after the tenant made a complaint, if the tenant is behind in rent, if the tenant has broken the lease in some clear way, like, causing disruption to other tenants or something like that, if the tenant caused damage intentionally, if the tenant says, hey, I'm going to punch a hole in the wall, and then when you try to evict me for breaking my lease, I'm going to say you retaliated against me. The law is written very carefully in such a way not to allow that. Or if the tenant stays past the end of their lease, the landlord is still allowed to evict them just like they have always been in Georgia. It is not considered retaliation if the landlord proceeds with an eviction under those circumstances.
Okay. So it does offer some protection to landlords. And that's interesting because Georgia is a very landlord-friendly state. At least I found it to be.
Yeah, I think that's true.
Okay.
And this bill, again, it's a very strong new tool for Georgia tenants, but landlords should take comfort in the fact that the legislators were very careful to draft it so that no landlord's rights are affected or harmed. And the good landlords, the ones who follow the law, who maintain their properties, who are responsible professionals, have nothing at all to worry about. It's really the slumlords who need to be worried about this law.
Okay, so right now, as it stands, there's no protection for. It's not a defense. It's not one of the defenses for people before July 1st.
That's right. We've got a little bit more time before that defense kicks in.
Okay, that's really good to know. Now, I want to know a little bit about how this law came into being. Atlanta Volunteer Lawyers had a role in this, in getting this law into play, right?
Yes, and before I answer that, let me just add one more really important thing about this law. So if the tenant does prove that they were retaliated against by the landlord, the law actually provides that they can win money, that the court can award them 1 month's rent plus $500 on top of that.
Okay, so statutory damages are included in that.
That's right. So landlords should really pause before they file an eviction and make sure they have proper grounds to do it. Otherwise, if the tenant proves that the tenant has been retaliated against, that landlord may end up paying that tenant for what they did wrong. So to answer your question, though, yes, Atlanta Volunteer Lawyers Foundation was one very small part of a big coalition of tenant advocates and organizations that came together to get this passed. It was called the Healthy Housing Coalition. And there were a variety of people who were part of that. Georgia Appleseed is another organization that does a lot of great work, another nonprofit in the community. You should have them on the show. They have a lot of interesting things to say about the work that they do, but they really spearheaded this and brought in legal aid and Georgia Legal Services and advocates for disabled people and elderly people, a lot of whom are renters, and really got us together to bring all of our energy together to get this law passed. So a bunch of us went and testified before the legislature. I testified in one of the committee hearings in favor of the bill. And, we all came together and addressed any concerns that the legislators had. And luckily, they agreed that this bill was needed and they got it passed.
That is excellent work. Okay, we are at the end of this segment again. Cole, will you give them some contact information for Atlanta Volunteer Lawyers once again?
Yes. If you have a legal problem or question, you can call Atlanta Volunteer Lawyers Foundation at 404-521-0790, 404-521-0790, or find us online at avlf.org.
You're listening to Lewis on the Law, and this show is meant to empower you, the listener. We are not meant to replace the advice of an attorney. It's only designed to give you information to help you handle legal issues. If you have a serious legal issue, contact an attorney. You can always contact me at jameslewislegal.com. You can give me a phone call at 404-610-0075, or you can email me at james@jameslewislegal.com. When we get back, we're going to kind of wrap up the eviction process. We're going to talk a little bit more about HB 346, and we're going to get into what's it like when you walk into that courtroom. You are listening to Lewis on the Law. My name is James Lewis, and once again, I want to tell you that this show is now streaming nationally. You can go to Spotify, you can go to Google Play, iTunes, and those are really the only ones that I know about, but I think there's more. You can stream the show. You can go to your favorite AI. You can say, hey, Google, play Lewis on the Law, episode 44 with attorney Cole Thaler, and this show will start streaming like magic. AI is so incredible. It's like magic, Cole.
That's amazing.
It is amazing. And if you hear a topic, if you have a topic that you want to hear on this show, go ahead and give me a call. No, don't give me a call. Email me, james@jameslewislegal.com, or you can go to my website, the contact page. On the very last page of my website, you can just drop me a message on what you'd like to hear, what topic you'd like covered, or if you have a question, and I'll bring an attorney on and we will talk about your issue on air. Now, when this show's been about the eviction process and we've gone through a lot, can you kind of wrap up the process, go from the whole starting of an eviction again, and just give us a nutshell overview of what happens in an eviction?
Sure. So again, in Georgia, evictions move very quickly. So a tenant, if their landlord follows the law, the landlord will make a demand for possession, meaning they'll tell the tenant they have a certain amount of time to get out. If the tenant is not out of their rental property by that deadline that was given by the landlord has the right to go down to the courthouse, file a piece of paper that in Georgia is called a dispossessory summons, also known as a dispo, also known as an eviction in layman's terms. And that piece of paper will be served on the tenant, meaning it'll be delivered to the tenant's home by a county marshal. And the tenant then has 7 days to file an answer. So really strongest recommendation that I can make, biggest helpful tip that I can offer is don't delay. Don't let the time slip away from you and say on day 8, oh, gee, was I supposed to do something with this piece of paper? Because you will lose your rights in court. Make sure you get back down to that courthouse, file an answer with the form that the court gives you, and then you will receive a notice of a court date, a time, and a courtroom. And make sure you're there. So a lot of tenants in Georgia they make the mistake of not being prepared, James. They show up to court and think, well, I didn't have to bring my evidence today because I'll just bring it next time I come.
It goes by. It happens fast, huh?
Happens fast. Be prepared from day one. If you have witnesses, bring them with you to your hearing. If you have text messages with your landlord or pictures of the things that weren't repaired, videos, letters, receipts, whatever it may be, your lease, bring all that with you. Be prepared and know what you're going to say. Of course, my number one recommendation is to get a lawyer if you can. Mm-hmm. But talking to folks, and the vast majority of folks, to be real with you, the vast majority of tenants in Georgia who are evicted don't have attorneys. So folks who are going it on their own, who are doing it by themselves, should be as prepared as possible. Make notes, make an outline. Lawyers do this all the time. I think non-lawyers don't realize that they are allowed to do that too. Write down what you want to say. In the heat of the moment, in the stress of possibly losing your home, people forget.
Oh, yeah.
When you think you're never going to forget to mention the rat infestation, you might actually forget that because you're so overwhelmed or confused or sometimes crying or just overwhelmed. So, I really recommend that people make notes of what they want to say, have all your evidence with you, and just pay very close attention to what the clerks and the deputies instruct. Be on time. This is another mistake that people make. They show up late to court. That's really a problem. And I know there's traffic and what have you, but, be on time, be early. Mm-hmm. Be early to court and just be as prepared as you can. Try to get some legal advice ahead of time if you can't get a lawyer. But just be ready. A lot of tenants really have good defenses or counterclaims that they don't bring up, and that's a shame.
Okay, can we go through the answer process real quickly and some of the defenses again? I want to kind of get into that because these shows go by quickly and people are listening on the radio, so let's rehash that.
Sure. So answer is a word that lawyers use. It just means your response to the lawsuit. Everyone is entitled, everyone who's sued, and an eviction is a form of a lawsuit, is entitled to respond, to say, hey, that's actually not right. And we call that an answer. So in most cases, in most civil cases, the person who's being sued has 30 days to file an answer. Evictions are different, 7 days, much more compressed time frame. Go down to the courthouse. The clerk will give you a form to fill out. It's mostly a checklist. and make sure you raise a legally valid defense. If you just, are getting evicted because you couldn't afford to pay your rent, you're going to have a hard time because that's not enough to stop the eviction. But you should be thinking about things like the conditions of the home, or do you know this person whose name is on the dispossessory paperwork? Is this your landlord? Is it true that you didn't pay your rent? Did you offer to pay rent? Did your landlord do something wrong, terminate your lease without a valid reason? Or you offered rent and they didn't accept it? Those are the kinds of things that tenants really need to bring up in their answers, as well as counterclaims, which is basically countersuing the landlord for things like failing to repair. You have to bring that up in your answer, or you've lost the chance to bring it up ever.
Mm. So are there other counterclaims that they can bring up other than failure to repair?
That's far and away the most common one that we see. Things like security deposits are usually not, it's not time to bring that up because the tenant is still living in there, and so that the landlord has not improperly withheld the security deposit yet. 99 times out of 100 what we see are failure to make repairs, and that has to be brought up as a counterclaim in that answer. Otherwise, the tenant loses their chance to ever bring that up.
Okay. So with the counterclaim, is a tenant actually entitled to damages?
Yes, absolutely. And we actually see this a lot. I'm happy to say at AVLF, it can happen and does happen that the landlord is suing you, let's say, for unpaid rent. The tenant raises a really strong counterclaim, and the tenant walks out of eviction court having won money in their favor. So let's say you didn't pay your $500 rent, but your landlord caused, $5,000 worth of damages to you. They didn't repair a flood and you lost all of your furniture. Yes, that tenant is entitled to seek and recover damages. In other words, to win money in court for what that landlord did wrong.
Okay, that is very, very important to know. So when a tenant is walking into a courtroom, what can they expect? I mean, what happens in the courtroom?
So it's different in every county. There are some counties where there might be just one or two other people in that courtroom. Here in Fulton County, the courtroom is going to be full. There might be 50 or
packed.
75, right? Standing room only in Fulton County in eviction court. So, you can expect to see a judge and a clerk and probably a deputy there to help keep order in the courtroom, and a whole bunch of benches where the tenant is going to sit quietly and wait for their turn to be called. Again, be sure to bring all your evidence with you. I can't tell you how many times I've been in the courtroom and heard a tenant who didn't have an attorney say to the judge, well, I have all my receipts at home proving that I paid all this rent. And the judge says, well, you should have brought it. Here you are. Today's your hearing.
Yeah, today's the day.
They're not doing you any good at home on your desk. So bring all your paperwork with you, and just make sure that you let the court know that you're there. If they take attendance, calling the calendar, make sure you stand up and let them know that you're present. And certain counties like Fulton has a mediation process, but I think that's pretty unique to Fulton County. So that may not be an option in the county that you're in. But if it is, that's a great opportunity to sit down with your landlord informally and try to come to a compromise.
So a mediation, what is that?
A mediation is where the two sides in a case, say the landlord and the tenant, get to sit down with a neutral third party, somebody who is not on anyone's side, but is there to help the two sides see if they can come to a compromise. And in Fulton County, it's a great program. Everyone who comes to eviction court is entitled to a mediation before they even get in front of that judge. And actually, in Fulton County, most cases do settle in that mediation room. So absolutely give it a shot. Talk to your landlord, let the mediator help you, see if you can work something out. Maybe you need more time to make a payment, or you just want some more time before you have to move out. You can come to a pretty creative resolution in mediation. So take advantage of that.
Okay, so that is actually really helpful. Okay, so mediation doesn't work. What happens then?
So then you do go in front of that judge. That's when you stand up at the podium or take the witness stand and get a chance to tell the judge your side of the story. You get sworn in to tell the truth. You will be sworn to take an oath of truth, and you explain your side of the story. The landlord goes first since they filed the case. They'll say whatever they're going to say about what you did wrong as a tenant, and then the tenant will have a chance to be heard. And the judge will let the tenant speak as long as the tenant wants to tell their side of the story. But it helps to be organized, to be clear, to be chronological. Don't jump around. I recommend that tenants start on day one and come to now. Don't talk about something that happened yesterday and then something that happened 6 months ago and then something that happened 2 weeks ago. Don't confuse the judge. You're not doing yourself any favors. Whether you're a landlord, whether you're an attorney or a non-attorney, you're not doing yourself any favors if the judge is confused. So make sure you're communicating clearly in a linear way and telling your side of the story, and you will be heard.
Excellent. Cole, this has been a great show. Can you go ahead and give our listeners contact information for Atlanta Volunteer Lawyers one more time?
Sure. Our phone number is 404-521-0790. That's 404-521-0790, or you could find us online at www.avlf, as in foundation.org.
You're listening to Lewis on the Law. My name is James Lewis, and you can always give me a shout out. You can give me a call at 404-610-0075. You can go ahead and email me at james@jameslewislegal.com, or you can go to my website. All of my old shows, actually, I haven't been updating as much as I should, but most of my old shows are archived on my website. You can go to the video blog page. These guys told me it's called a vlog these days, so I named it. I gave it a slug of vlog, and I have a podcast page where my old podcasts are all archived there. You can go there. You can catch up with what's been going on in the legal world. We'll have another great show next week. Before I leave, I need to mention our producers, the siren of sound, the sound garden of, as you will, Sam Davis, and our villain of video. That's right, the one and only antagonist Anthony Cook over there. See you guys next week.